the country and have no uniform system of administration as Parliament has the power to prescribe the structure of administration. The Union territories of India can be classified into following based on direct control of Union. Cultural distinctiveness. Pondicherry, Daman and Diu, Dadar and Nagar Haveli. Strategic importance. Andaman and Nicobar Island, Lakshadweep. Political and administrative consideration. Delhi and Chandigarh. President may appoint governor of a state as administrator of adjoining unit. Adjoining who shall exercise his functions independent of his coms. Lieutenant Governor, Delhi, Pondicherry, Andaman and Nicobar Islands. Lieutenant Governor. Administrator, IAS officer, Chandigarh, Dadar and Nagar Haveli, Daman and Diu, Lakshadweep. Important points. Union Territory of Pondicherry and Delhi have legislative assembly. Delhi and Union Territory of Delhi and Pondicherry has legislative assembly with Council of Minister and Chief Minister. The size of COMS is to be maximum Council of Ministers is to be maximum 10% of the Legislative Assembly. Parliament can make laws on any subject given in three lists. Power also extends to Delhi and Pondicherry even though they have their own legislature. Pondicherry and Delhi can also make laws on any subject of state list and concurrent list except laws related to public order, police and land. The President may frame regulations for peace, progress and good governance for all UTS except Delhi and Pondicherry. Parliament is empowered to constitute a high court for any of the union territory or even can declare an existing court. There are high court, for example, Delhi High Court of Delhi, Lakshadweep High Court of Kerala, Chandigarh High Court of Punjab and Haryana, Andaman and Nicobar Island High Court of Calcutta, Pondicherry High Court of Chennai, Dadar and Nagar Haveli, Daman and Diu High Court of Bombay. Advisory Committee. It is a link between Parliament and Union Territory and consulted by government in regards to general question of policy relating to administration of subjects in state list. All legislative proposals in state list pertaining to territories. Matters related to annual financial statement of territories. 69th Amendment of 1991. Union Territory of Delhi shall be called National Capital Territory (NCT) and shall have a legislative assembly with members chosen directly by people from territorial constituencies. Assembly shall make laws on matters enumerated in state list except matter of public order, police and land. If any provisions of law made by a legislative assembly with reference to any matter which is repugnant to any provision of law made by Parliament with reference to that matter, then law made by Parliament shall prevail, and the law made by Legislative Assembly shall to the extent of repugnancy be void. If law made by Legislative Assembly is preserved for consideration of precedent and have reserved his assent. If the law is preserved for precedent is preserved for consideration of precedent and is reserved for his assent, then such law shall prevail in National Capital Territory. However, Parliament can make laws adding to, varying or repealing laws made by Legislative Assembly. There shall be Council of Ministers, not more than 1/10 of the total member of Legislative Assembly. There shall be Council of Ministers, not more than 1/10 of the Legislative Assembly, member of the Legislative Assembly with Chief Minister at its apex to aid and advise it governor in exercise of its function. In case of difference between opinion of Council of Minister and its governor, Governor shall refer it to the President for his decision and shall not according to the direction given by President and shall act according to direction given by President. A special provision for scheduled and tribal area of India. According to Article 244 Clause 1. The provision of 5th schedule shall apply to administration and control of scheduled area in every state other than Meghalaya, Tripura, Assam and Mizoram. 244 clause 1 states that the provision of this 5th schedule shall apply to administration and control of scheduled area in every state other than Meghalaya, Tripura, Assam and Mizoram. According to Article 244 clause 2, the provision of 6th schedule shall apply to administration and control of tribal areas of Meghalaya, Tripura, Assam and Mizoram. Administration of scheduled area 5th schedule. The governor of each state having scheduled area have to submit a report to the president annually or whenever so required by the president. The governor of each state having scheduled areas have to submit a report to the president annually or whenever so required by the president. Executive power of union extend to giving direction to the state regarding administration of these areas. A tribal advisory council consisting of not more than 20 members should be considered in each state having scheduled areas therein for their advancement and welfare. The governor is empowered to direct that any particular act of parliament or state government does not apply to scheduled areas, or if applied, then with specific modifications and exceptions. Governor has been given power to direct any particular that at any particular act of parliament or state government does not apply to scheduled areas, and if applied, then with a specific modification and exceptions. Constitution provides for appointment of a commission to report on administration of scheduled areas and welfare of scheduled tribe in state. The president can appoint such commission at any time but compulsorily after 10 years from commencement of constitution. Administration of tribal area. 6th schedule. Tribal areas in the state of Assam, Meghalaya, Tripura and Mizoram have been constituted as autonomous districts, that is, falls under executive authority of state concerned. The president at any time by order direct that whole or any specified part of scheduled area cease to be a scheduled area. The president at any time by order direct that whole scheduled area or any part of the scheduled area cease to be scheduled area or may increase the scheduled area in state after consultation with the governor of the state. If there are different tribes in an autonomous district, governor can divide the district into several